This podcast is not legal advice and should not be relied upon as such. You should always obtain legal advice about your specific circumstances.
Hi, and welcome to our Smarter Lawcast on business restructuring and being risk ready. In this episode, we're discussing the important considerations you need to think about when buying a distressed business. My name is Scott Butler, and I'm a partner in Hall and Wilcox's dispute resolution practice, specialising in restructuring and insolvency. Today, I'm joined by Ed Payton, an M&A partner, and David Catanese, a partner in our employment and workplace relations group. Ed, David and I are members of Hall and Wilcox's restructuring and turnaround team, which mainly focuses on assisting underperforming businesses to restructure their business affairs so that they can survive and thrive. But we also assist clients to take advantage of opportunities that present themselves when other businesses are in financial difficulty. Welcome to you both.
Thanks, Scott.
Morning, Scott. Morning, David.
Ed and David, we've all been involved in assisting clients to acquire businesses that are in financial distress, whether that's outside or inside a formal insolvency process, such as a voluntary administration. And when such businesses are put up for sale, there are generally really tight timeframes for the sale process, given the financial pressures the business is facing. And so to take advantage of such buying opportunities, clients need to be prepared for and understand the different dynamics which arise from when you're buying, let's say, comparing that to buying a high-performing business. Ed, I might ask you this question first. What are some of the things that clients need to consider to be ready and able to buy a distressed business at such short notice?
Yeah, thanks, Scott. There are a few things. I think the main thing, really is just sort of being aware, of the industry you're in, having situational awareness. So you need to know, who are the sort of target businesses in your industry or, or sector, who's of interest to you, how they're traveling, and often, you do know that within your industry, and you need to be ready, if they do come on the market. Another thing which is really important, so that you're ready, to buy a distressed business at short notice, is resources. So there's a question about, do you have a good relationship with your bank? Do you have other sources of funding that you could tap into quickly? Would you be ready to move quickly if an opportunity presented itself? And the third thing, which I think is really important, is people. So, do you actually have the resources in your management team to keep the business running, and to do a due diligence, which might be a very rapid and detailed, sort of process. And that can be quite a strain on a business, which people don't anticipate. The other thing might be, whether you've got established relationships with your advisors. You certainly want to have relationships in place so you can just pick up the phone and they'll swing into action for you.
Yeah, they're all good points. And as I mentioned before, the sale process for distressed business, they're usually truncated. They're really quick because the business is usually trading at a loss, and so a quick sale is often critical. And so that sort of truncated quick sale process, what issues does that generally present?
Well, I mean, in a broad sense, it just changes, changes everything. So it changes the amount of time you have, the amount of due diligence you're able to do. It changes the way you, might structure your offer and the confidence you'll have that you're making the right offer. So I think the key thing, in terms of the due diligence is sort of focusing on the key issues, material issues. We talk about red flag issues. What are the big sort of walk away type issues that you need to identify in due diligence, and do you know what they are and how you're going to find them and how you're going to focus on them, and is the material available to you in a data room to do that. And then I think the sort of second thing is in relation to to the offer, you may be able to get comfortable on a certain amount of due diligence, and that could be financial, legal, and other. But you may just also have to price the risk. You may not be able to bottom out all the issues or get all the documents you need or have time to go through it all sort of thoroughly. So, those are a couple of the challenges. I might sort of run through a couple of kind of high risk issues or sort of red flags that we see, Scott. So, one of the key issues, which people are often familiar with in any deal, is tax risk. This is sort of less of an issue in sort of fast moving, distressed deals, because they tend to be asset acquisitions or business and asset acquisitions, if there's goodwill. Here, if we're not buying the structure, we're less worried about, the tax risk, the tax history and tax liabilities, but there might still be indirect tax that's relevant, particularly some GST and stamp duty. And, there can be hidden traps with stamp duty. Stamp duty is actually quite complex and varies obviously from state to state. And there are some strange legacy stamp duty type issues. And there are also some more, recent additions even in property and construction in the last couple of years. The next sort of issue I want to mention was sort of really around that traditional area of claims, disputes and litigation. So everybody knows, if you're doing an acquisition, you do litigation searches. Now, if you're not acquiring a company, you're not taking on those liabilities necessarily, but if a business does have a track record of having lots of, claims or disputes or litigation, then that may lead to you forming a view about how that's been run and whether it's been sort of, well run. The other thing you can have, are legacy issues with claims that say relate to employees that haven't resulted, in litigation. And David will talk more about employees later. The third sort of issue is just a quick one, really around sort of cyber and ESG. So ESG is sort of an acronym that everybody is sort of using at the moment, and for good reason. Environmental issues, social issues and governance issues are all really important in due diligence, and there's an increasing focus on ESG in due diligence, and that can be very relevant to distressed deals and fast moving deals as well. Cyber risk and information sort of security, data security, privacy, systems, issues around security are key. We've seen so many high-profile examples, of where good companies, haven't been able to get that right yet. So that's really important. Yeah.
I guess the thing that we see, when we're on these deals, is that the contract, the traditional sort of clauses you'd have in a contract, you really have to be thinking about, how is your contract going to be a bit different when you're dealing with buying a distressed business, and what are the key sort of things from a contractual perspective that you'd expect in these situations?
Yeah, that's great question, Scott. I think it's interesting. I look at this from two different perspectives. I think you look at it from the seller perspective, and then you also sort of look at it in terms of the sort of the buyer's position in a distressed deal. I think from the seller's position, if the seller is has been formally appointed, so it's an administrator or a liquidator, or in other circumstances, this happens sort of in the private equity context as well. But particularly here, we're talking about sort of distress, and let's say it's an administrator. And an administrator, doesn't know the history of the business. They don't want, personal liability for what they, sort of put into the contract, what they commit to in the contract. They'll want limitations of their liabilities. Same with liquidator, and so they'll give you very limited, sort of warranties, and you won't get indemnities. In a traditional sort of M&A situation, you'd want an extensive, set of warranties and indemnities from a seller and probably a warrantor, so an individual sitting behind the seller, to back up those, those warranties. And the warranties protect you if there are gaps in your due diligence. In a fast-moving deal, you don't have that same protection. You probably don't have access to warranty and indemnity insurance because the deal's it's all moving too fast. Even though there are some interesting products out there, and you need to be conscious that there will be more risk in that contract, than in a normal situation where you have a more generous and purchaser sort of favourable or even balanced sort of contract. These contracts will be quite seller favourable, and therefore you need to price the risk.
Yeah, and I was about to say, really, it's about pricing risk. So I totally agree with you. David, just moving on to you, one of the big issues in acquiring a business is taking on all the employees. And, I and everybody else only needs to read the news to see that even the most diligent employers are subject to underpayment claims at the moment. And it just shows me that employment law is complex and difficult, and it's difficult to get right, even for the most diligent and large corporations. So when you are looking to acquire a business with employees, what are the three key questions that businesses should be asking themselves?
Thanks, Scott. Yeah, the employment law aspects of these types of transactions is really important. And in my experience, it's something that's thought of second. There's an opportunity or a need to move on a business if that's necessary. And these are what's front of mind in each party's approach to these sorts of transactions. The opportunity. Then there's, well, what's the deal going to look like, and all of the things that Ed mentioned. Pricing risk. Price is usually very front of mind, and then the employment law aspects come in later, and that's usually where I get involved in these types of transactions. And often I see that there are things that the parties simply haven't turned their mind to, which really can be material to the transaction. And they're very important. And the three, I think, biggest questions that parties on either side of these types of transactions should really be asking is, well, what is it that we're buying or selling? You really want to have a very clear idea about what the transaction is all about. Is it about novating service contracts? Is it about acquiring assets? Do you need to acquire people with special skills or workforce capacity in an industry? Are you simply trying to take out a competitor? What is it that you're trying to achieve through the transaction? Because that's really going to drive the strategy from an employment law perspective. And just to give an example, if you're, do you want to retain the existing workforce of the business that you're acquiring or not? And if not, for example, what are the redundancy payment consequences? If it's a large, long-standing workforce, that could run to the millions of dollars. And is that going to be material to the transaction going through? Similarly, is there insurance that covers severance payments? You really want to know that at an early stage. It's going to be material to the deal. So, what actually is it that the transaction is all about? Another question that I think all parties should ask themselves is, where are they going to get the data from? Realistically, how sophisticated are these businesses? Do they have internal resources to produce reports on employee liabilities, claims, and so forth? Employee data, contact details, industrial arrangements, contracts of employment, all these things that really need to be considered to get the transaction across the line. How are you going to get it? Where's it stored? Is it offshore? Are there third parties? Is it going to be reliable? How much due diligence are you going to need to do about the data?
David, what if you just can't, you can't get that data because this business there's probably a reason it's in distress. It's probably not managed that well. Its records may not be that great. What if there's just gaps?
Scott, there's always going to be gaps, particularly when there's significant time pressures. These aren't ordinary circumstances where you do a full due diligence, and you and Ed have spoken about that. So how do you, price that risk? Maybe it comes into the purchase price. Maybe it's simply a risk that you're prepared to take. And getting in experienced advisors is really important on that score as well. People who've seen these sorts of transactions and have a better idea of the, the known unknowns. How many red flags are here? How serious are they? What is the level of risk? Are you still prepared to go through with the transaction without knowing? For example, I worked on a transaction recently where there are some real questions about the legal status of some industrial instruments that applied to the workforce. And so there was a question mark about how these industrial instruments would transfer over to Newco, which could have a material impact on labour costs. And really where we got to is in the time that was available, is that a risk that the purchaser is prepared to take? In that case, they were. And it worked out just fine. But, there's certainly gaps, but getting advice about those gaps is really important.
So, David, I'm assuming that, some transactions are easier than others, and every now and again, things aren't really, as smooth as you would hope they are. And so from an employment perspective, what are the sources of these complications which arise that you see?
Yeah, good question, Scott. Look, whenever something arises in a deal, a complication, there's always a way through. There's always an ability to navigate it. Now, whether that path through is acceptable to both parties is another question. But there's no issue that can come up that can't be considered and worked through. But where I see clients and parties to these deals becoming frustrated and perhaps having to go backwards in a transaction is where unrealistic timeframes have been imposed. For example, when the deal needs to be done by Friday. Okay, great. All your advisors can prepare the documents and do all of this. But if you want to retain employees, it's an asset sale. Employees need to be employed by Newco. You actually have to terminate their old employment and employ them at Newco, and that means actually engaging with individuals. For example, a workforce, there's going to be people on leave, there's going to be people on workers' compensation. If people aren't away that week, but you need them to be at work on Monday for the new business, realistically, how are you actually going to manage that? And if that hasn't been thought about when timeframes are being set, it can be really frustrating for all parties. So where I see parties becoming frustrated and potentially deals coming unstuck is where commitments are made with respect to timing that don't actually allow for everything to be done that needs to be done from an employment law perspective.
So I guess then there's going to be, particularly in these fast-paced, distressed deals, a real fine line between getting the deal done in a time frame where the business, the vendors can still keep the business afloat, I guess, to get it through to the end of the sale process, and having enough time to actually, do the deal properly from an employment perspective.
Absolutely, Scott. And I think the best way to avoid problems in that space comes back to that point about where are you getting the data? Get that data about the employment law issues early, get some advice about what the realistic timeframes are going to be, where there is going to be actions that must be undertaken that can't be done immediately, perhaps because you have to engage with other parties or employees. Identify that really early, feed it into your timeframes so there aren't nasty surprises.
Yeah. And, the sale of a business, particularly from an employee's perspective, and one in a situation where the business may not have been going that well, it's a big thing for the employees. And so just from a communications perspective, in terms of, telling them about it, what should the buyer and the vendor be doing in that regard?
Yeah, it's so important, Scott, particularly for Newco, if they will be taking on some of the workforce. Morale is really important. You want people to, really hit the ground running with the new entity so it doesn't interrupt operations if that's material. If you're not acquiring, If Newco isn't acquiring employees, then it's less of a concern for Newco, but certainly a concern for Oldco, who needs to deal with employee liabilities and likely or often industrial issues. At the same time, is it a business deal? And, you know, employees sometimes have rights under industrial instruments to be consulted about these types of things. Sometimes they don't, and you don't need to overshare or create angst amongst a workforce that might turn out to be unnecessary. So you don't want to jump the gun about what might occur, but you really should be thinking about what is the best way to communicate to employees, come up with a strategy that's flexible. You might need to change it as you go, but really speaking to employees about this is a transaction that's coming. If people will be transferring, give them some information, make it clear at a very early stage. There will be no diminution in your terms and conditions of employment. All of your prior service and accrued long service leave and annual leave will go across to the new business. You know, if that's going to happen, tell your people, and it will put their minds at ease and make the whole thing a lot easier.
Just jumping in, just sort of picking up on that from a transactional sort of lawyer's kind of perspective. You know, I agree with all that's been said, and I think it's really interesting when you think about that communication piece. You know, with employees in different sort of deals, sort of scenarios. So obviously in a non-distress situation, just as a point of sort of contrast, you know, you want good three-way discussions between the seller, the buyer, and the employee. And a structured process, enough time, give people time to look at an offer, take it home, you know, speak to their family, come back, you know, sort of on the Monday and sort of, you know, and hopefully sign up. In a distressed scenario, you know, it's different. So if it's an administrator might be, you know, managing, you know, employees, you know, expectations and morale through a very stressful, you know, period. And that may be on top of a difficult period for the business prior to the appointment, and then and dealing with multiple, you know, sort of bidders on a, you know, on a sale where there's no real certainty, you know, whether a deal will go through at all and who it will go through with and when, right? So you know that a skillful administrator will manage, you know, the employee communications sort of in that, you know, in that scenario. You know, we had a different scenario recently where we acquired, you know, assets from a liquidator, and the biggest issue there was that, you know, the business had been was basically being sort of broken up. People were leaving and going to competitors. There was a piece of the business which we liked, which we wanted to acquire with the people, and it was a discrete team. And the trick there was really making sure that the communication, you know, with the employees was such that they understood, you know, that there was an opportunity there for ongoing employment and for the team to stay together, and that there was a really credible buyer there ready to go and give them a new chance. And because what you don't want is to be halfway through a process like this and then you lose the people, because the business is nothing without the people.
Yeah, no, that's a really good point. Well, thank you very much, Ed and David, for your expert comments today. I guess from my perspective, you know, summing up, the distressed sales, they're different to ordinary sales. There are shorter timeframes. Buyers need to be ready to act at short notice. They need to expect not to have perfect information, and they need to price the risk that comes with not having perfect information. And at the same time, they need to place sufficient importance around the acquisition of employees and not leave that as an afterthought. Well, thanks everyone for listening today. As always, please get in touch with us if you have any questions. You can find our details on our website, which is hallandwilcox.com.au, or connect with us on LinkedIn. If you enjoyed today's podcast episode, then rate, review, or follow our podcast wherever you get your podcasts. Thank you.